Here's Johnny. Hey guys, welcome to Federal Criminal Law once again. It's our first class of the session. As you can see, a little bit even less flattering picture of me this time around. This is actually Jack Nicholson in The Shining, and the reason he's included here is because he's a good representation of federal criminal law. If you ever saw The Shining, Jack's character starts off as a nice, mild, mannered, passive, limited kind of guy, and he ends up an uncontrollable monster. And that's exactly the story of federal criminal law. So let's get to it. Hopefully you've done your reading for the first assignment. We're talking about the scope and the basis of federal criminal law. And I'm going to walk you through it right now in a little bit more detail as well. First of all, let's look. I've got some PowerPoint slides prepared to help us think through and talk about the whole issue of federal criminal law. And before we talk about federal criminal law, we have to talk about the nature of the federal government itself. As you guys all probably know from your constitutional law classes, the federal government was initially seen as a limited government. It was supreme in power within its own sphere, but limited in nature. And the way we often talk about it in terms of federalism, but the notion of a limited federal government with plenary powers remaining in the states. But another way to think about it is through a principle sometimes called subsidiarity. And many would argue that the subsidiarity principle is actually the principle that underlies our federal system. And to give you a sense of that, I've got two quotes here in this first PowerPoint slide. The first one is from what was known as the Virginia Plan, which was submitted as part of the Constitutional Convention drafting experience. And it was about the nature of the federal government. It said, resolved that the national legislature ought to be empowered to enjoy the legislative rights vested in Congress by the Confederation, that is, under the old Articles of Confederation, and moreover to legislate in all cases to which the several states are incompetent or in which the harmony of the United States may be interrupted by the exercise of individual legislation. So this was an initial statement about what the federal government should be. This was actually accepted by the Constitutional Convention, but then it ended up being translated into, rather than a general statement of federal power, it became instead a specific list of federal powers, which we see in Article 1, Section 8 of the Constitution, listing the various powers of Congress, including the commerce power and many others. But again, that list of powers originally came from this general principle that the national government should do whatever it is that is beyond the power of the states to do, or whatever is necessary to preserve harmony among the states. And again, this is very like a statement of the principle of subsidiarity. We have an example below. The second quote does not come from the history of the Constitution, but rather is a theoretical statement about the principle of subsidiarity. And it says, a community of a higher order should not interfere in the internal life of a community of a lower order, depriving the latter of its functions, but rather should support it in case of need and help to coordinate its activity with the activities of the rest of society, always with a view to the common good. So what does this mean? Well, it means that society should be ordered in such a way as to allow lower-level institutions to perform their proper function, and higher-level institutions should only come in where necessary to preserve public good. So if you think of it, you can start at the very beginning and say, what the family can do on its own, the family should do, and the state shouldn't intervene except where necessary to protect and preserve the family or individual members thereof. Similarly, what the local town can do, it should do, and the state shouldn't intervene. What the state can do, it should do, and the federal government shouldn't intervene, etc., except where necessary, again, to effectuate some public need. And again, the idea is that the lower level you get, the more local you get in your handling of concerns, generally the better off you are. And the higher level institutions like the federal government should come in only where necessary and only where the lower order institutions can't really manage on their own. Okay, so this was the basic principle underlying the federal government when it was first instituted. And that fact is reflected in the constitutional text itself, and particularly in its treatment of crimes. At the time the Constitution was adopted, virtually all criminal law was state criminal law. The federal government did not have much involvement in criminal prosecution or law enforcement at all. In fact, there are only 3 crimes specified in the Constitution itself. One is the crime of treason, mentioned in Article 3, Section 3, the crime of counterfeiting in Article 1, Section 8, and the crime of piracies and felonies committed on the high seas and offenses against the laws of nations, Article 1, Section 8. So again, you can see these are all crimes where it's necessary that the federal government be the unit of government that does the prosecution. The crime of treason is treason against one's country, not against any one state within the country. Because it is by nature a crime against the federal system, it's appropriately prosecuted in the federal system. Similarly, counterfeiting, Congress had the power to print money under the U.S. Constitution. So money is a federal interest, not a state interest. And so again, counterfeiting is appropriately prosecuted at the federal level. And then finally, piracies and felonies committed on the high seas. These are crimes that are committed outside the jurisdiction of any given state, and they usually involve international law of some kind or another. So again, given the location of such crimes and given the fact that they implicate foreign policy, these are clearly crimes that are appropriate for federal prosecution, and from the very beginning they were considered federal crimes. Also in 1790, I have not included it here, but the first Congress did enact a federal criminal statute that was somewhat more expansive than this list of crimes in the Constitution, but not very much so. And the list of crimes in that statute were crimes that all directly implicated some kind of federal interest. You know, the stealing of a federal vessel, for example, or a ship at sea. And again, the vast majority of criminal prosecutions happened at the state level, not at the federal level. Now, that's not true anymore. As we'll see in a minute, the list of federal crimes has expanded exponentially since the founding of the Republic. And just as a starting point, though, a quick reminder that anytime you have a federal criminal law, there must be some constitutional basis for the enactment of the law. Although state governments have plenary power to define crime and to punish crime, the federal government, by definition, only has limited power, and so there has to be the crime as defined in the federal statute has to fall within one of Congress's enumerated powers in Article 1, Section 8. And I've listed here on this slide some of the powers that are most commonly used to justify federal criminal laws. So the most commonly used one is the commerce power, the power to regulate commerce with foreign nations and among the several states and with the Indian tribes. As we will see in a little bit, this power becomes the basis for the vast majority of federal criminal laws based on a very broad reading of what it means to regulate commerce. There's also some other bases, though, that are sometimes used. The power to tax and spend for the general welfare is, again, a potentially very expansive source of power for the federal government, in some ways even more expansive than the commerce power. And later this semester we will talk a little bit about how that works. But sometimes federal criminal laws are based on that power. The postal power, the power to establish post offices and postal roads. Now that isn't, on its face an obvious source of power to create federal criminal law, but in fact one of the oldest and most often used federal criminal provisions is based on this power, and that is the mail fraud statute. And we will be studying mail fraud quite soon in this class. Again, a very important, very long-established statute. Finally, in Article 1, Section 8, there's what's known as the Necessary and Proper Clause. And this is not itself an enumeration of a power, but it simply says that Congress can also make all laws which shall be necessary and proper for carrying into execution any of the enumerated powers vested in the United States by the Constitution. So the Supreme Court has interpreted the Necessary and Proper Clause to sometimes expand the scope of congressional authority to enact criminal statutes beyond the scope of its enumerated powers. And we'll talk about how that works in just a little bit as well. Now, as I said a minute ago, the history of federal criminal law has been a history of expansion, right? That's why we've got Jack Nicholson from The Shining as our background picture for today. It was initially very limited in nature, did not cover much, but in the last several decades, the expansion of federal criminal jurisdiction has been huge. I mean, it's expanded consistently throughout American history, but it's really expanded quickly in the last several decades. And just to give you an example, some statistics are listed here. So in the 25-year period between 1970 and 1996, 40% of all federal criminal laws were enacted. So we see a very vast expansion of federal criminal law in that 25-year period. And in fact, if you limit it to the 15-year period between 1980 and 1996, 15% of all federal criminal laws were enacted. So huge momentum towards enactment of federal criminal law. There are currently at least 4,000 federal criminal laws, but nobody knows for sure how many there are. And that's in part because many federal regulations are cross-tied to federal criminal statutes in such a way that if you violate the regulation, you also commit a federal crime. And because there are so many federal regulations and because they change so often, no one knows, again, exactly how many of them can be prosecuted, violations of how many of them can be prosecuted as crime. Now, this expansion has also included an expansion to cover lots of traditionally local types of crimes that you would normally expect to be prosecuted at the lower level. So now this is just a list of some crimes that are now federal crimes: carjacking, drive-by shootings, arson, various types of theft, manufacture or possession of child pornography, solicitation to commit a crime of violence, trafficking and even simple possession of narcotics, possession of firearms by all sorts of categories of people, including felons, fugitives, drug addicts, mental defectives, and also people who've been convicted of misdemeanor domestic abuse, and those who are subjected to restraining order not to stalk, harass, or threaten an intimate partner. And those last two categories are quite interesting, right? Because the underlying crime is a quintessential local crime: domestic abuse, stalking, harassment, and yet and crimes again that are not even necessarily categorized as felonies within their home states. Although certainly any kind of domestic abuse or harassment is a serious crime, but not at the highest level of serious crimes like murder or rape. And yet it's the basis for federal jurisdiction. Finally, use or carrying of a firearm during and in relation to a crime of violence or a drug trafficking crime is also a federal crime. So as you can see from the list, again, federal criminal law now covers virtually the entire waterfront. Almost anything that can be prosecuted locally as a criminal matter can also be prosecuted federally. Now, again, the nature of the movement within federal law towards prosecution of quote-unquote street crime or traditionally local crime can be seen graphically through the graph I've put in front of you. If you notice, the graph shows the number of defendants prosecuted in the federal system in the years between 1982 and 2000. And during that time period, we see a large, almost doubling of overall prosecutions, right? The top of the box shows us overall prosecutions went up from 40,000 to almost 80,000 in those years. It has, of course, since continued to rise. But the bottom graph kind of breaks down the nature of the increase. And if you notice, there are two main categories that are driving the increase in prosecutions: drug offenses and public order offenses. And now public order offenses are largely constituted by weapons offenses. So drugs and guns, to a large extent, have driven the increase in federal criminal prosecutions, again, from the 80s through the early part of the 21st century. Now, in recent years, again, drugs and guns continue to be quite important. Immigration offenses have also increased quite a bit since 2000, largely due to 9/11 and the increased focus on terrorism. One of the ways the federal government has tried to prevent terrorist acts has been through increased enforcement of the immigration laws, with the result that many people who are in the country illegally but who have nothing to do with terrorism are nonetheless getting deported when they might not have in prior years. But again, drugs and guns are a very large part of the increase in federal prosecution. And so, as you can see, as the current slide tells you, since 1980, prosecution of drug crimes has increased by 332%, almost 4 times faster than the overall federal prosecution rate. Drug prosecutions are now about a third of the federal docket. The federal prosecution for mere possession of narcotics, that is not even trafficking but just possession, increased about 1,000% between 1994 and 2001. Federal gun prosecutions have also more than doubled since the year 2000. Once again, street crime has become an increasingly important part of the federal system, federal criminal prosecution system, that is, and so when we talk about federal criminal law now, I mean, probably when you in the past have thought about federal crime, you may have thought about drug prosecution, certainly, but you probably thought primarily about white-collar crime, crimes involving, large-scale financial fraud, etc., and even drug prosecutions at the higher level, the cartel level, rather than the individual user or street-level dealer level. But in fact, federal prosecution now covers all those things. It covers everything from the very most sophisticated, high-end criminals to the lowest level drug dealers and drug users. And with the result that almost any crime, again, can be now prosecuted as either a federal crime or a state crime. And so now, let's talk about how it works, and particularly I'm going to focus on the Commerce Clause, because the Commerce Clause is the primary basis for most federal criminal laws, and the Supreme Court has identified several different ways in which the legislature can use the Commerce Clause as a basis for jurisdiction to make some kind of activity a crime. And so I've got a list of types of commerce power jurisdiction up here on the PowerPoint slide for you right now. The first one is, the court has said, Congress can make a law that relates to the channels of interstate commerce. And by channels, we mean roads, rivers, railroads, any of the things that people use to cross state lines. Also, Category 2, Congress can regulate instrumentalities of interstate commerce or persons or things in interstate commerce. And that basically means an instrumentality of interstate commerce is something that can carry you or your words or expressions across state lines. So an instrumentality would include a car or an airplane or a train, but also a telephone, if the telephone carries signals across state lines, a computer that's hooked up to the internet, etc. Those all count as instrumentalities of interstate commerce, and Congress has the power to regulate those, and so it can create federal crimes relating to instrumentalities or persons or things in interstate commerce. The third category is one that's perhaps most controversial, And that is, the court has said Congress can regulate intrastate activities that substantially affect interstate commerce. So you may be doing something purely locally, not crossing state lines, not engaging in commerce across state lines, and yet if your conduct has a substantial effect on interstate commerce, then your conduct can be prohibited and in fact made criminal by Congress. And we'll talk quite a bit about how that works in the second part of today's lecture. Finally, this is not an official category of commerce power jurisdiction, but in fact, at least the lower federal courts have recognized it as a basis for commerce power jurisdiction, and so it's worth listing here. And we'll talk about how it works in a little bit. And these are situations where the statute, the federal criminal statute, contains what's known as a jurisdictional element showing an individual effect on interstate commerce. That is, where the statute is written in such a way that the prosecutor is required to show some kind of effect on commerce that flows from a given crime. That will be sufficient to establish federal jurisdiction, even if the effect is minimal, if it's a de minimis effect rather than a substantial effect. All right. Now, I want to talk, sort of having laid out kind of the basics, the constitutional basics here of commerce power jurisdiction, I want to talk about the way statutes are drafted in order to incorporate commerce power jurisdiction. That is, to make sure that that in fact the statute it comes within Congress's commerce power. So the first type of statute I want to talk about is statutes that involve crossing of state lines of one kind or another. And I'm going to give you some examples of statutes. First, an early example was from the Mann Act, which was adopted in the early part of the 20th century. And it makes it a crime for any person to knowingly transport in interstate or foreign commerce any woman or girl for the purpose of prostitution or debauchery or for any other immoral purpose. Okay, so this was a statute that that made it a federal crime to cross state lines with one's mistress, for example, for the purpose of engaging in an adulterous affair. Very much a local activity, one might say, activity that's not normally criminal, and yet the Mann Act made it a federal felony. By the way, the Mann Act has since been updated so that it only covers transportation across state lines to further prostitution or sexual trafficking of one kind or another. But in any event, you can see it's a statute that makes it a federal crime to cross state lines with some bad purpose. And excuse me, that's the way many federal statutes are drafted. They're drafted as though it were the crossing of state lines that was the criminal act, and that the thing we normally think of as a crime, whether it be engaging in prostitution or something else, is a secondary condition. You know, it may be okay to engage in prostitution, but boy, if you cross state lines to engage in prosecution, then you're really in trouble, right? That's the way the Mann Act is phrased, and that's the way most federal criminal statutes are phrased. And so there were a number throughout the 20th century of statutes like the Mann Act that made it a federal crime to do something while crossing state lines. So, for example, in the case of Champion versus Ames, the Supreme Court upheld a statute that made it a crime to carry lottery tickets across state lines. The Dyer Act made it a crime to move stolen motor vehicles across state lines. The Lindbergh Law made it a crime to move kidnapped victims across state lines. The National Stolen Property Act made it a crime to move stolen property across state lines. Fugitive Felon Act made it a crime for fugitive felons to cross state lines. All these statutes gave the federal government jurisdiction because the crossing of state lines was involved. Now, this principle that you can make something a federal crime if it involves the crossing of state lines has been expanded in recent years to cover not only the crossing of state lines, but the causation of someone else to cross state lines, or even the use of an article that has previously cross state lines. So, for example, if you look at the federal carjacking statute, which is again up on your slide, it says whoever with the intent to cause death or serious bodily harm takes a motor vehicle that has been transported, shipped, or received in interstate or foreign commerce from a person by force or threat of force violates the statute. So notice, in this case, the criminal is not moving a motor vehicle across state lines. What gives the federal government jurisdiction is simply the fact that at some point in the past, this motor vehicle has crossed state lines. And so unless you commit the crime in the state in which the car was made, virtually every federal carjacking will now be, or I'm sorry, virtually every crime or every carjacking will be a federal crime. Also, the Interception of Electronic Communications Act involves, again, essentially wiretapping when any component of the equipment you use has previously been transported in interstate or foreign commerce. So let's say, for example, you are wiretapping someone and you are recording the information onto a cassette tape. If that cassette tape at some point in the past crossed state lines, like let's say it was made in Japan and sent to the United States before you started using it, that's going to be enough to give the federal government jurisdiction over a crime. So again, this was one of the earliest ways in which federal criminal jurisdiction was expanded. I'm sorry, I didn't have the PowerPoint slide up for all of you, but here it is now. You can, if you need to, you can pause your recording and look at the provisions I've been quoting. Again, this is one of the earliest forms of expansion of federal criminal jurisdiction, and the reason for it is pretty obvious. Number one, because it involves the crossing of state lines, it does seem to come within the commerce power pretty obviously. And also, you can make the argument that if a crime involves the crossing of state lines, then it's the kind of crime that usually the state government is not going to have the capacity to deal with on its own, because there will be witnesses and evidence located in several states, and so maybe we need national jurisdiction so that a single governmental body can bring together the whole case and prosecute the offenders. And there's certainly some logic to that. Of course, I'm not sure that logic supports the expanding of the principle to include crimes that simply involve some item that has crossed state lines in the past, like a car that gets carjacked or a cassette tape that's used in wiretapping. But nonetheless, the courts have generally upheld such statutes, even though, again, it's kind of hard to find a federal rationale for them. Okay, I want to talk now about another type of statute that is also used to ensure that there is federal jurisdiction. And these are statutes where the words affecting commerce are included in the definition. And one key statute that uses this wording is the Hobbs Act. The Hobbs Act, which makes it a federal crime to obstruct, delay, or affect commerce in the movement of any article or the movement of any article or commodity in commerce by robbery or extortion. So again, as with the statutes involving crossing of state lines, it's worded strangely so that it appears that the crime is the affecting of commerce, and then the subordinate clause is by robbery or extortion, right? In reality, of course, the crime is robbery or extortion, and this affecting commerce language is what gives the federal government jurisdiction over the crime. Now, when the court has interpreted language like this in the past, it has said that when Congress uses the word affect commerce in a statute, this signals that Congress wants to use the full extent of its commerce power in effectuating the statute. The statute will go as far as possible to convey jurisdiction on Congress. So in a number of cases interpreting the Hobbs Act, the court has allowed prosecution based on one theory, which is known as the depletion of assets theory, and another which basically has to do with the idea that if you rob a store, for example, of some money, and the store buys some of its goods in interstate commerce, then you've depleted the store's assets. You've made it a little bit less able to buy goods in interstate commerce, and therefore your robbery affects interstate commerce by making the store a little bit less able to buy stuff. Okay, that's the depletion of assets theory. And again, notice it only requires a de minimis effect on commerce. So if, for example, I walk into a Walmart and go up to the cash register and rob the register of $50 and walk out of the store, is that in reality going to affect Walmart's ability to purchase stuff? No, of course not. But it does, at least theoretically, have ever so slight an impact on Walmart's ability to buy goods. And since Walmart does buy goods in interstate commerce, under the depletion of assets theory, I can be prosecuted under the Hobbs Act. Okay, so again, very local crime that can now be prosecuted federally. Similarly, some courts have said that if the crime prevents the use of an item that's previously been shipped in commerce, then again, that might make it a federal crime. So again, if I rob Walmart and I steal a Justin Bieber DVD of his latest movie, then I am preventing the use of that DVD in commerce, and if it's previously moved across state lines, that could be a basis for jurisdiction. So again, when you see a statute that has this language, this affecting commerce language, courts have interpreted it very broadly to permit jurisdiction under the Commerce Clause. Finally, we have some statutes that contain no jurisdictional language at all. And one example of that, again mentioned in your reading, is the Consumer Credit Protection Act, which was enacted in the 1960s and makes it a crime to make any extortionate extension of credit under any circumstances, any extortionate extension of credit at all. No need to show an effect on commerce in an individual case. No need to show the crossing of state lines. Nothing like that. So on its face, it looks like a very broad statute that would go potentially beyond the scope of Congress's commerce power. But the court in Perez versus United States actually upheld the statute. And in so doing, it engaged in sort of an interesting kind of reasoning, which I'll talk about now, and it comes up again in our cases for today, U.S. versus Lopez in particular. So what does the court say about extortionate extensions of credit? Well, this statute was designed to stop loan sharking. Okay, where a guy, somebody's gambling, somebody extends them credit so they can gamble, but if you don't pay them back, then you're going to break their legs, right? And they're going to charge you 20 or 30% interest until you pay them back. Now, in the Perez case, what happened was the defendant actually engaged in such a transaction, but it was for a small amount of money. It was only $500. The defendant himself was a purely local kind of criminal, no ties to organized crime as far as anybody knew. And so when he was prosecuted, he made the claim that, look, you can't get me, Congress. If the state wants to prosecute me, it can, but my crime is purely local in nature. It has nothing to do with interstate commerce. The Supreme Court ultimately rejected this argument, though, and for interesting reasons. So here's what the court in Perez said. The court says, when Congress enacted this statute, it made some findings of fact about organized crime and about the aggregate effect of extortionate credit transactions. Basically, what Congress said was that organized crime is a national problem. It results in billions of dollars of loss every year, and that one of the main tools organized crime uses to further its interests is loan sharking. And so Congress decides to outlaw all loan sharking, regardless of whether the individual loan shark is himself or herself part of organized crime. And the court says this case is a lot like the case of Wickard versus Filburn, which is a very famous Commerce Clause case from the 30s, in which The defendant in that case had grown more wheat than he was permitted under federal law, but the wheat he was growing for his own use, to feed to his animals and to his family, and he argued that he couldn't be prohibited from growing and using his own wheat because he wasn't engaging in any kind of commerce with it at all, much less interstate commerce. But the court in Wickard said no. In fact, Congress is trying to regulate the overall market in wheat, and your wheat overhangs the market because, number one, by growing your own wheat, you're preventing yourself from having to go to the store and buy some. So that's reducing the amount of commerce that goes on. Moreover, if the price of wheat goes up, you're going to be tempted, rather than use the wheat yourself, to sell it at the higher prices. So there's always that threat that your homegrown wheat will flow into commerce. And so the court in Wickard versus Filburn said, when Congress is regulating a class of activities that it has the power to regulate, then it can include within the regulation even purely local activities that are part of that class. And the fact that your own activities are purely local in nature doesn't give you the right to exempt yourself from the statute. So similarly, flash forward to Perez, the court said here, if you're a purely local loan shark, tough luck, because Congress has the power to regulate loan sharking as a class because it is so closely associated with organized crime and because it is national in nature, and the fact that any individual loan shark may not himself be doing anything more than local crime won't save him from Congress's power. So again, this is what's often called the class of activities approach to commerce power, or the aggregation approach to commerce power. And the reason it's called aggregation is because the idea is if you aggregate the effects of every individual little crime and add them all up together, then all together as a group they may create a substantial effect on interstate commerce, even though each individual crime may not. Okay, so that was the state of the law prior to the Lopez case. The Lopez case, a case that had the potential to really change the nature of commerce power jurisdiction, and it did have some change, but not as big an effect as many people thought it would. But U.S. versus Lopez, it's a case from 1995. It was the first case in about 60 years, I believe, in which the court had overturned an act of Congress because it exceeded Congress's commerce power. So it's worth taking a look at. So the Lopez case involved the Gun-Free School Zones Act of 1990, and I've got the text, the relevant text from that statute up on your PowerPoint. The Gun-Free School Zones Act forbids any individual from knowingly possessing a firearm at a place that he or she knows is a school zone. Okay, so again, notice it's very much like that loan sharking statute in Perez. It does not contain any jurisdictional language whatsoever. It's just, if you possess a firearm in a school zone, then you've committed this federal crime. And this statute was challenged as exceeding Congress's power under the Commerce Clause. Now, it's an interesting case because it's in many ways. But one thing that's interesting about it is it shows the effect of overlapping federal and state criminal laws. Because in Lopez, the defendant was initially arrested and charged under state law because there was a Texas statute making it a crime to possess a gun in a school zone. But then, a day after he was charged in state court, the state charges were dropped and he was moved into the federal system as well, presumably because law enforcement decided to make an example of him and to use this new Gun-Free School Zones Act, which had been adopted just a few years before in 1990. And again, when there is overlapping federal and state criminal jurisdiction, the federal government always has the authority to bring federal charges. There's no procedure behind it. There's no process that has to be followed. If the federal government wants to prosecute you, they can. And if they choose to set their sights on you, usually you'll end up with a sentence that is significantly longer than it would have been in the state system. So, all right. So that's what happens to Lopez. He gets moved into the federal system. He claims that that the statute exceeds Congress's commerce power jurisdiction, and in fact, the Supreme Court agrees with that rationale. Now, to get there, we need to first of all talk about the government's argument in support of the statute, and then what the court said in response. So the government, in supporting the statute, basically argued that this statute is no different than the loan sharking statute in Perez, and that all you need to do to show commerce power jurisdiction is to aggregate the effects of the crime. So in this case, the government said, look, if you aggregate the costs of gun crime on society, it's easy to show that they have a substantial effect on interstate commerce. Okay, gun crime in the aggregate costs lots of money. People commit many robberies with guns. They shoot people with guns, send them to the hospital, or kill them. There's costs associated with that. If you look at all those costs together, they have a substantial effect on commerce. And the government went further than that and gave also a couple more specific rationales. They said that the prevalence of guns in any given area may have an effect on people's willingness to travel to such areas, and so the federal government has an interest in eliminating guns so that people will be more willing to travel. Moreover, the government argued that guns in school zones can have an effect on education because it's harder to get a good education if you're worried for your own personal safety all the time because people are bringing guns to school. And if students don't get good educations, then they'll be less productive members of society when they grow up. And so the aggregate effect of that will be very significant. And the government says, we all know, as the "We Are the World" concert once said, we believe that children are the future, right? And so we need to protect our children in order to protect our future. Now the court, so you can see this reasoning is very much like the reasoning the court employed in the Perez case. And yet in Lopez, the court rejects this reasoning and says this is not enough to show commerce power jurisdiction. Why not? Well, the big problem is this. This sort of reasoning, where you kind of aggregate the effects of all instances of a given type of crime to show a substantial effect on commerce, this kind of reasoning can really cover virtually any kind of activity you can imagine. So, for example, let's say Congress enacted a federal shoplifting statute, so that if somebody shoplifts a piece of gum from a store, they can be criminally prosecuted in the federal system. The court says, look, under the reasoning employed by the government here, there'd be no problem with making shoplifting into a federal crime because if you aggregate the effect of all shoplifting that occurs within the country, altogether it imposes a significant monetary loss on stores in the aggregate, and so it has a substantial effect on commerce in the aggregate. So same goes for anything else. Family law could be federalized on the grounds that family problems in the aggregate result in a substantial effect on interstate commerce, et cetera, and so forth. And so the Supreme Court says we need some limiting principle here. If we're going to allow aggregation at all, we have to have a way to limit it so that the crimes that get prosecuted will be crimes that truly belong in the federal system and not just in the state system. And so the court raises a series of questions about a given regulation to help us figure out whether, in fact, it can be prosecuted federally or not. And the first one, and the biggest one, is whether the thing being criminalized is an economic or commercial activity. If it's an economic or commercial activity, the court says you can aggregate the effects of the activity in order to show a substantial effect on interstate commerce. Now, the court doesn't really tell us what economic or commercial means. So, for example, was the loan sharking in Perez a kind of commercial activity? I mean, there certainly was a monetary transaction in that case, but it was also a violent crime. So not entirely clear what the court means by commercial or economic. But nonetheless, it draws this line in the sand, and it says if the activity is commercial in nature or economic in nature, then you can aggregate its effects to show a substantial effect on interstate commerce. If it's not economic in nature, then you can't. And in this case, gun possession is not an economic activity in any way, and so the court says you can't aggregate its effects. The second thing the court asks is, well, even if it's not economic in nature, is the activity an essential part of a larger regulation of economic activity? Again, think of Wickard versus Filburn, where growing your own wheat isn't necessarily economic in nature, but the prohibition on homegrown wheat was an essential part of Congress's larger regulation of the wheat market. And so if there is that kind of a relationship between the regulation and regulation of a market like that, then that might be enough to establish federal jurisdiction. But once again, in Lopez, the court says, no, we don't have anything like that here. This is a standalone prohibition on a certain type of gun possession. It's not related to any larger regulation of economic activity. And so we're going to say it's beyond Congress's commerce power. Finally, the court notes that in this case there are no congressional findings about the effect of gun possession on interstate commerce, and it considers that fact another reason to strike down the law. Maybe, remember in Perez there had been findings about organized crime and about loan sharking, and that was one of the reasons Congress upheld the law in Perez. The court says there are no such findings here. And finally, there's no jurisdictional element to ensure in a case-by-case way that the crime affects commerce. So again, think of some of those statutes we talked about that require the crossing of state lines, or that require that one affect commerce by committing a robbery or whatever. If the statute had such a jurisdictional element, the court implies then maybe that would be enough to save the statute, but there is no such element here. So the court strikes down the Gun-Free School Zones Act of 1990, and it sort of sends a shot across the bow for Congress, giving them a warning that maybe the court is going to do something to seriously limit the scope of Congress's commerce power. Now, this warning in the Lopez case turned out not to be quite as big a deal as it looked like it was going to be at the time it was decided. There was, as your notes indicate, after Lopez, there was one case the Supreme Court decided after Lopez in which it struck down a law on Commerce Clause grounds, and that was U.S. versus Morrison, a case involving the Violence Against Women Act. That statute had provided a federal civil remedy for victims of gender-motivated violence, and in fact, in that case, the Congress had made findings that gender-motivated violence in the aggregate had a substantial effect on commerce, but the court nonetheless struck down this law. Why did it do so? Well, it did so because it found that crimes of violence, gender-motivated crimes of violence, are not economic or commercial in nature, and therefore you can't aggregate their effects to show a substantial effect on interstate commerce. Because once again, as the court said in Lopez, if you could aggregate the effect of non-economic crimes, then there'd be no limit to the commerce power at all. The court also notes in U.S. versus Morrison that the statute has no jurisdictional element, which would limit the scope of the statute in any way. So that statute struck down as well. But Congress got around. I mean, so again, from Lopez and Morrison, it looked like the commerce power was going to be used in a fairly strong way. But I'm sorry, limitations on the commerce power would be used in a strong way. But the effect of the statutes has been limited in a couple ways. One is through statutory drafting. So remember, in Lopez, the Gun-Free School Zones Act of 1990 is struck down. But then in 1995, very shortly after Lopez was decided, Congress reenacted the Gun-Free School Zones Act. And here's the statute in which it reenacts the act. It says, now it's unlawful to possess a firearm that has moved in or that otherwise affects interstate or foreign commerce at a place that the individual knows or has reasonable cause to believe is a school zone. So notice the language that's been added to it. Now we have both language involving crossing of state lines, that is, the firearm has moved in commerce in the past, or if the firearm otherwise, if the possession otherwise affects interstate commerce. That is, if the prosecution can show that the individual possession in a given case has some effect on interstate commerce, then the person can be prosecuted. So Congress gets around, and this law is still on the books. It has survived for the last 15 years. So Congress got around Lopez by simply adding that jurisdictional language, the movement in interstate commerce and the affecting interstate commerce language, and by so doing it has insulated the statute from constitutional review. The other reason that Lopez and Morrison have turned out not to be quite such a big deal is that the court limited their effect in the case of Gonzalez I believe Raich. It's either Raich or Reich. I can never be sure how to pronounce it exactly. But that was a case involving medical marijuana. The Controlled Substances Act of 1970 had classified marijuana as a Schedule I substance, meaning that there's no medical use for it, and it's highly addictive, and therefore it's always illegal. But the state of California in recent years had actually decided to permit the use of medical marijuana under state law. And so the question arose then, well, it's great that the state is permitting the use of medical marijuana, but can users still be prosecuted federally under the Controlled Substances Act? And so a lawsuit was brought involving this issue, and it eventually made its way up to the Supreme Court. And a lot of people thought that the Controlled Substances Act would be struck down, at least in part. And the Controlled Substances Act, very much like the Gun-Free School Zones Act, contained no jurisdictional element whatsoever. It simply regulated the market in narcotics, and it included both international, interstate, and local activities. But nonetheless, the Supreme Court upheld the law, even though it had no jurisdictional element, and it held that the law could be applied to people who grow their own medical marijuana. Why? Well, again, think back to Wickard versus Filburn. That's turned out to be the most important case as a reference for these newer cases. That's the homegrown wheat case. And remember, in that case, the court had said Congress can limit the amount of homegrown wheat you grow for your own use, again, because of the threat that your wheat will flow into the market if prices go up, and also because your use of the wheat forestalls your need to go into the market to buy it. The court in this case says, medical marijuana is a lot like that, in that you may be growing it for your own use, but there's always going to be the temptation that if the price is high enough, you'll actually grow more and sell some of it in the market, or perhaps even sell all of it in the market if the price is high enough. And so the court says Congress could have rationally concluded that in order to make its overall banning of marijuana effective, that it had to include medical marijuana, homegrown medical marijuana, within the prohibition because of the threat that homegrown medical marijuana might pose to the market. Raich, in many ways, is a case that shows the importance of the necessary and proper clause of Article 1, Section 8. Remember, we talked about that earlier in today's lecture. Article 1, Section 8 lists the powers of Congress, but then the necessary and proper clause also says Congress can pass any law necessary and proper to effectuate one of its enumerated powers. And in Gonzalez v. Raich, both the majority opinion and also Justice Scalia's concurrence, which you don't have in your reading, emphasize the fact that even if growing your own marijuana is not itself a commercial activity, you're growing it for your own use, nonetheless, there's enough of a logical connection to commerce that Congress could rationally conclude that it was necessary to outlaw it to effectuate its overall regulation of the market in marijuana. So now, if there's going to be a challenge based on the Commerce Clause, one of the things has to be, obviously the first thing you need to ask is, well, if it's a case involving local activity, you need to ask, is it economic or non-economic in nature? If it's economic, you can aggregate the effects. If not, you can't. But now, even if the activity is non-economic in nature, you need to ask, well, okay, but is this law outlawing this activity related to some larger regulation of economic activity? And if there's some rational relationship between this law and that larger regulation, then the law will be upheld, even though it covers purely local conduct. Now, a couple final points. One other thing the court has done in recent years to avoid having to make too many constitutional decisions is that it's narrowly construed several federal statutes to avoid constitutional problems. So, for example, in Gonzalez versus Oregon, mentioned in your notes, the Supreme Court interpreted the Controlled Substances Act to only give comprehensive federal regulatory power over recreational drug use, not medical prescriptions. And thus, the Attorney General did not have the power to adopt regulations to invalidate Oregon's Death with Dignity Act. So again, practice of medicine is a traditionally local activity. There was some worry that Congress may have exceeded its power if it's federalizing all local medical practice. But again, the court avoids the problem by interpreting the Controlled Substances Act narrowly. Similarly, in Jones versus United States, the federal arson statute was interpreted not to cover owner-occupied private residences. And so, again, a possible constitutional problem that may have arisen from it, if you could charge someone with a federal crime for burning a private home, it was avoided by interpreting the statute narrowly. Okay, so that's our introduction to these Commerce Clause issues. Sorry if it ran a little bit long. We'll have a couple follow-up lectures relating to applications of the principles articulated in these cases that we've read for today to give you a sense of how this stuff works in practice. So I will talk to you then. Bye.